Now, a three-judge bench has begun hearing the case challenging the implementation of the three health laws. Justices Alfred Mabeya, Robert Limo and Fridah Mugambi heard the petitions, complaints on how the Social Health Insurance Act risks locking out a section of Kenyans from accessing crucial health services on account of mandatory registration, which they term, quote, unconstitutional. The respondents, however, who include the government, defended the position, saying provisions in the law are geared towards facilitating the efficient delivery of health services. Let's get more from our very own Mary Mwaki.
The petitioners assert that the Social Health Insurance Act violates several provisions of the Constitution concerning healthcare. Advocate Harrison Kinyanjui, representing the petitioners, took issue with the provision that Kenyans not registered under the Social Health Authority will not access medical services in public hospitals, terming it as a violation of the Constitution.
A person shall not be denied emergency medical treatment. There are no antecedents, no preconditions there. You will not be denied. So there's a doctor there on call for you, but the moment you bring that person, the reception say to the, you have that right violated.
NHIF should transition from collecting voluntary premiums from the informal sector and the poor and instead adopt tax financing.
However, Senior Counsel Fred Ngatia told the court of the necessity for the government to compel all Kenyans to register with the Social Health Authority and keep their payments up to date, adding that failure to do so would compromise the delivery of government services.
NHIF should transition from collecting voluntary premiums from the informal sector and the poor and instead adopt tax financing. Universal health care cannot be achieved through a voluntary mechanism. Article 43 right will collapse.
The petition filed by Joseph Enoch Aura, the Kenya Medical Practitioners and Dentists Union, the Union of Kenya Civil Servants and other health bodies, opposes the mandatory registration of all Kenyans above 18 years of age to the Social Health Insurance Fund. The petitioner's lawyer singled out Section 26, subsection 5 of the Act that directs the national and county governments to deny services to anyone not registered for SHIF, terming it illegal under the Constitution of Kenya.
It creates, in violation of Article 12(1) of the Constitution, a dichotomized class of Kenyans. You have those who are paid up and registered and fully paid up. They are able then to, pursuant to this section, to access government services and so on and so forth. And you have another class of Kenyans who are probably not registered, will not access.
So let no Kenyan ever approach the High Court saying that this act deprives them emergency treatment. The so-called to access public service is not equal to denial of constitutional rights, because constitutional rights are not public services.
The three-judge bench is also expected to determine whether the Digital Health Act that outlines a system of digitally acquiring and maintaining health records of Kenyans violates the right to privacy. The case continues on Thursday. Mary Mwaki, Citizen TV.